evening, we are especially pleased to present a program to you. And the title is Nothing Sacred? Snyder versus Phelps and Free Speech. When is there a conflict of free speech? What about compromising free speech? Does the law provide special protection to some and not to others? We have two distinguished presenters this evening with us, and I'm very pleased to introduce them to you. Now, many of you will have your own thoughts about free speech, and I don't believe there's anyone here not in favor of free speech. Sometimes we just wonder, how far does it go before it starts to violate rights of others? This evening we have Christina Wells with us, and she's an Enoch H. Crowder Professor of Law at the University of Missouri and a First Amendment scholar. She joined the University of Missouri of Law faculty in 1993, where she teaches freedom of speech, remedies, administrative law, and gender and the law. Wells has been a visiting professor at the University of Illinois College of Law and also in the Czech Republic. In 2009, she received the Shook, Hardy, and Bacon Research Award for her article on the constitutionality of statutes regulating funeral protests. Wells received her JD from the University of Chicago and her BA from the University of Kansas. Stephen McAllister is the Solicitor General of Kansas and a professor of law at the University of Kansas. Prior to joining the KU Law faculty in 1993, he clerked for Justice Byron White and Clarence Thomas at the Supreme Court. Previously, McAllister practiced with the Los Angeles firm Gibson, Dunn, and Crutcher in their Washington, D.C. office. He served as the first and only solicitor of the state of Kansas from 1999 to 2003 and was dean of the law school from 2000 to 2005. McAllister received his JD and his BA from the University of Kansas. The First Amendment. It protects speech that espouses offensive or unpopular positions. Most, if not, as I said before, all believe in free speech. Tonight's program will be a lively and a civil debate presenting the arguments of both sides of the pending Supreme Court case, Snyder versus Phelps, which will be heard before the Supreme Court October the 6th. This case highlights the conflict between protesters' First Amendment right to freedom of speech and the rights of grieving families who wish to mourn their fallen sons and daughters in privacy and with dignity. We all have our feelings about what the Phelps family and free speech means. But this case is not all about the Phelps. It's about a much larger issue, and that is free speech. What we're more familiar with is what happens locally or in our state. But 48 states joined together to file a brief. So that means that it goes beyond Kansas. They are concerned as well. This evening, Bill Lacy, director of the Dole Institute of Politics, will moderate this panel between, as I said, two very distinguished University of Kansas graduates. Bill?
Please welcome our guests, everyone. My first question, professors, is very simple. Why did the Supreme Court choose to hear this particular case?
It's a good question why the court took this case. Frankly, I think Professor Wells and I we actually spoke together a year ago, last summer, to a group of the attorneys general from across the nation, and we were talking about funeral protest laws. And this case was then working its way up through the courts, and I don't think the Court of Appeals had yet decided. The jury had imposed liability, and I think we both suspected that the likely answer on appeal would be the liability wouldn't stand. And so when that was the answer from the Fourth Circuit, frankly, I wasn't surprised at all. I was much more surprised when the court took the case, because I do think it's probably easier to invoke their previous decisions to uphold the result that the Phelpses are not liable than it is to hold the contrary. So I'm not sure why they took it. There was the usual reason for the Supreme Court to take a case is either they think it's obviously wrong or there's a split of opinion in lower courts, but there's no other decision like this out there to be conflicting with this one. So my only guess is that at least some of them are extremely interested in the issues this case presents, and maybe view it as an opportunity to clarify what the law is in this area. But that said, I wouldn't know if it's ones who want to clarify that the First Amendment protects this, or maybe there are one or more justices who want to take a hard look at whether this in fact was the correct result in the trial court below.
Talk like this. I don't disagree with anything that Steve said. Law professors are on all sorts of blogs and listservs, and when the court granted cert, everybody in my field, the free speech field, there was a collective, huh? We really just didn't know why exactly, for exactly the reasons that Steve said. There is a possibility, this case involves the tort, the sort of lawful wrong of intentional infliction of emotional distress, and this particular issue does involve a slightly different twist on that than the court has ever decided. And so it may be that the court's finally going to decide an issue that it had never had to decide, and that a lot of people had wondered about. That might be one reason why it decided to go ahead and take the case. But that doesn't account for all of the other things that it agreed to decide. And there's a whole bunch of stuff sort of floating around this case. It's several different issues. So this is one of the more perplexing decisions for the court to have taken. I think all of us, and I think you and I both talked about this last summer, thought that what the issue on funeral protests that would make it up to the Supreme Court was going to be a challenge to one of these statutes. And that was for sure going to make it up there. But this is an unusual issue, and I think the only thing that I can come to the conclusion of is that there are two lower court opinions. The district court imposed liability, and then the Fourth Circuit reversed. Neither of them is terribly good. They're not in the sense that they have bad outcomes, but they're not very well explained, and they're not terribly well reasoned. And the Supreme Court, I think, might be worried about that in this particular area. So it may have decided, given that there's already some lack of clarity, they wanted to go ahead and really issue a strong, forceful opinion. In what way, we're not sure, but it may just be that they wanted to clarify the law.
I think if we took a poll here tonight, everybody would agree essentially, in their opinions about the Phelps. But this case really isn't about the Phelps. What's the real crux of this case? What's the key issue in this case?
Well, I'll take a crack at that first. I think what's at issue is partly suggested by perhaps the title of this program, Is Nothing Sacred? Is there no limit to what people can say, where they can say it, when they can say it in the United States? And I think that's sort of a big picture issue. I mean, the Phelpses can do this and basically walk away from it with no legal responsibility when, frankly, they are targeting a private event. They are targeting a private family. They are doing it because they know the attention it gets. There are lots of other ways they could express their message, and they do. But they're choosing one of the most, we would say, outrageous ways to do it that one can imagine. In fact, in 200 plus years of American history, apparently no one else did imagine it because no one else has done it the way they do it. And so I do think it does present for the court very hard facts, and there are actually a lot of factual issues in this case and problems with the record and what exactly was proven or not. But just taking their general behavior, it presents the court with a serious question of, is nothing sacred? I suppose even if the Phelpses win, you could argue still maybe the home is a place people could be protected from this sort of thing, but that may be the only place. And so I think this is a real test of really strong facts, testing how much we believe in certain principles and whether those principles do have limits.
Where the Phelps are allowed to run amok, marauding through funerals, screaming wildly with bullhorns, waving their offensive signs, right? The free speech jurisprudence that already exists allows the government to regulate a lot of disturbing and invasive protest activity already. You can't trespass into a funeral. You can't even go to one uninvited. Those are considered to be private ceremonies. So the crux of this is whether or not a group of people who stood more than 500 feet away, who obeyed all police directives, and who by all accounts protested relatively peacefully, and by the way, the plaintiff in this case, the father of the unfortunate young man who was killed, whose father didn't even see the signs until several days later or hours later at a funeral protest or at a news broadcast or on the web, whether that is considered to be disruptive of a funeral, right? You can regulate a lot of these things by having funeral protest statutes in place, and almost every state does now. So you can tell people to stay 500 feet away. You can tell them they can't be noisy. The crux of this case comes down to whether those things aren't enough and whether you should be allowed to sue someone because the message that they have on their signs or on their internet posting is so offensive that you think it inflicts emotional distress or invades your privacy. And the regulation of offensive speech is something the court's been very concerned about for a long time. And I will give you that the Phelps, they're entrepreneurial in the creativity with which they've done this, but they're hardly the first set of protesters or speakers to be incredibly offensive. Neo-Nazis threatened to protest in Skokie, which is a predominantly Jewish suburb with a heavy concentration of Holocaust survivors. The Klan protests. There are people who have done very offensive, very awful things. But we're not going to limit the decision in this case only to the Phelps. It just doesn't work that way in terms of the way the tort liability works.
Were the protesters, the Phelps who were involved in this, were they in any way violating any laws at this funeral?
Not that I'm aware of. I mean, that's a point I've noted, and they're a family of lawyers, as most of you probably know, so they understand the law, and their goal is typically to follow the law, and certainly if the law enforcement says, stand here, not here, that's what they do. So they certainly would have tried to comply with all relevant laws.
Maryland does have a funeral protest statute in place now, but it didn't at the time, I think. And so they were subject to police directives, and I think it's understood by both parties that they did obey those.
Can both of you kind of give us a little bit of the history of this case? I know that it's been, it's gone through a couple of appeals, but kind of describe how it came up through the chain of courts.
This is a pretty simple one, actually. Lots of cases can be really complicated, but this one involved Mr. Snyder, who is the father of Matthew Snyder, the son whose funeral that Phelps protested at in Maryland. Reasonably quickly after the funeral and after he was very upset, and understandably so, decided to file a lawsuit because I think he wanted the Phelps to be punished. And I think his motive is to essentially stop, I think bankrupting them may be one of the ways to stop some of the protesting. At least I've seen that in the press. I don't know whether he's actually said that. So he filed a lawsuit for a lot of different torts. And a tort is just a legal wrong, right? It's just a way that you can tell someone you've hurt me. And so a lot of things that are criminal, that the criminal laws cover, also are covered in tort law. So assault and battery are torts. Well, he sued for invasion of privacy, which is a common tort in almost every state, and intentional infliction of emotional distress, which is also a tort. It's less favored, but it's certainly one that almost every state recognizes, if not all states. You're actually the torts professor, so you know better than I do. He also sued for libel, right? Said that some of the things on your internet posting, because they had an internet posting, they held signs. Am I allowed to say what the signs say, or should I? They were offensive. They were not friendly signs. Things like "Thank God for Dead Soldiers," "God Hates You," "Pope in Hell," those are the more mild ones. These are the types of signs they hold at the funeral. The internet posting was a comment on Matthew Snyder's being raised in the Catholic faith and how his parents, who were divorced, had basically ruined his life, and how the Catholic faith was a terrible thing. And it was a little bit more in your face than that, but that's the general gist. Mr. Snyder sued, claiming that there were lies, false statements of fact about his son, and also that these statements intentionally inflicted emotional distress and invaded his privacy. The district court said he could not prevail on the libel claim. So even the district court said, like, there are no false statements of fact that damage your reputation because nobody believes what the Phelps say. Right? So they're not false statements of fact, not provably false. But they did prevail. He did prevail on the intentional infliction of emotional distress claim and the invasion of privacy claim. It was originally $10 million. I think it was $2.5 million or something like that in actual damages from the compensatory damages, and then several million additionally in punitive damages. That verdict was immediately appealed to the Fourth Circuit, the federal court, circuit court for Maryland, and the Maryland Circuit Court last fall said, no, you know what, the First Amendment comes into play here. And the district court had considered First Amendment arguments but rejected them. The Fourth Circuit considered the First Amendment arguments to be more important and basically said that unless there was a provably false statement of fact, even with intentional infliction of emotional distress or invasion of privacy, that Mr. Snyder couldn't recover. You can add whatever you need to add to that.
No, I think that's pretty much it. I will say in the trial court, it was a jury trial. So once the judge did decide to let certain claims go forward, it was a jury that decided the torts were committed. And interestingly, and it could be important legally, there's a lot of argument in the briefs in the Supreme Court about what happened, but the fact of the matter is the Phelpses did not appeal the sufficiency of the evidence from the trial, from the jury's determination. So legally, when the jury found the elements of these torts were met, that's over, because now the Phelpses are simply arguing on appeal. The First Amendment immunizes us even if we did these things. And so that's important from our perspective, because there's a lot of argument in the briefs about exactly who saw what when and what happened and what effect it had on everyone. But from the state's perspective, the case as it comes to the Supreme Court is really not about are the elements of the tort satisfied. The court has to take that as a given that they are. And so really the issue now in the Supreme Court is, does the First Amendment basically immunize them even though a jury found that they committed these state law torts?
So is it fair to say that the reason that the original verdict was set aside was because of First Amendment?
Absolutely.
That's exactly it.
Absolutely.
So then does that become the focal point of the Supreme Court case?
Well, it is, and my point is it really should be the only focal point. There are amici who've come in the case, for example, and argued, oh, the Snyder didn't even prove the elements of the tort under Maryland law. But I don't think the Supreme Court's going to get into that, because I really think that's off the table by virtue of the Phelpses have not appealed that question. They're just arguing First Amendment protects us, First Amendment protects us.
And there,
Sorry about
No,
that.
that's okay. I mean, there is certainly a number of us noted that realistically a lot of the elements may not have been met, but I think Steve's right that for the most part, well, I think some of the factual issues may come into play in how the court applies the First Amendment. I don't know that the court will say the elements of the torts haven't been met. That may not be its concern. I think it's very concerned with the First Amendment issues that are floating around here.
Okay. Well, tell us, and you'll have to explain this to me, and maybe, I assume all of you aren't attorneys out here tonight, because I'm certainly not one. But are the Phelps speaking on a matter of public concern? Now, what does that mean, and why is it important to this case?
Well, certainly the states have argued they're not necessarily speaking on matters of public concern when they attack the Snyder family. Obviously they are, if they're talking about war, or they're talking about gays serving in the military or whatever. Those kinds of issues obviously are of public concern. But when they're attacking a particular family and talking about this soldier and his family who had no connection to much of what they talk about, really, those people are not really part of the discussion of what is a matter of public concern. And the difficulties with this case is that much of the law that exists here at the Supreme Court is defamation law. So it's all driven by defamation notions. And being a matter of public concern matters in defamation because the court is given more protection when speech involves matters that are of interest to the public. Obviously, they're going to make it more difficult for people to sue when, for example, a government official is criticized. Whereas if they're just talking about someone's private life, and it's a private citizen, not in the public eye, the court has said, Well, those First Amendment protections may not apply to the speaker in that setting. And that's a concept that the Fourth Circuit invoked here in arguing that because they are speaking on matters of public concern, the First Amendment is more implicated. But it's a serious question in the case, because really what the Phelpses are doing is saying we can take any issue in any person and turn it all into a matter of public concern. If they don't believe that divorce is right or legal in God's eyes, then any person who's ever been divorced becomes a target, potentially under the Phelps' worldview. If they think the Catholic Church is evil, then any Catholic becomes a target in the Phelps' view, because under their view, and the view that we argue the Fourth Circuit wrongly agreed with, it's a matter of public concern if you implicate that person in any way. So in other words, you can take an issue, and then everyone who's a member of the class that might connect to that issue is no longer really private. And the argument the Fourth Circuit and the Phelpses make is that the First Amendment protects them. And the states, obviously, and the Snyder family disagree with that.
Well, I do agree with Steve that I think the issue of what is a matter of public concern is not one that the court has defined very well. And it is pushed by this issue of libel law, which largely has to do with restoring your reputation. And those issues are different than what we're talking about here, which is largely an issue of emotional distress and being traumatized. And I think that that's a very real emotion that occurred here. I guess I take a little bit of issue with Steve's analogies, because I think, in fact, you do have a right to talk to someone, and it is an issue of public concern to say, I think that you're going to hell because you got divorced. That may, in fact, be an issue of public concern if you think, that divorce is bad, right? Or I think because you're Catholic, that you are, destined for a terrible afterlife because it's the wrong religion, right? The idea that you can't talk about somebody particular, and that somehow takes it out of the First Amendment and not public discourse by particularizing speech about an individual, can't be right. I mean, there has to be some other standard there. We do that all the time. Think about criticizing a developer. We have a developer in Missouri, in Columbia, who's very unpopular. What if you were to hand out leaflets that criticized that developer, held them up to ridicule, mocked them, right? That's clearly an issue of public concern, but you are using that developer and criticizing them specifically, right? What if you just held them out as an example of everything that was wrong with, environmental racism, right? So particularizing speech cannot be the answer to why it isn't contributing to public discourse. There are times when speech clearly does go beyond the pale and isn't public discourse anymore, but it's not just because you're talking about a particular person. All protesters target people. Right? They don't just go stand out in the middle of the field and talk to nobody about nothing in particular. You're protesting a particular thing or a particular action. You will have a particular audience in mind. When the Supreme Court was talking about targeting and targeted protesting and talking about how difficult and painful that was, it was talking about people who were literally trapped in their homes by the notion of a protester, and they had no other place of refuge. Your home is special, right? It is the place that you can go to, and you have a right not to be targeted there, right? But when you go out in public, you don't always get to be free of all of that. You certainly have a right to be free from disruption and harassment and threats and violence, but you don't necessarily have to be a right to be free from offensive speech that happens to use your identity or someone you love's identity as an example, unless there's something else going on there.
Well, I guess that's where we would certainly join issue here. The argument that we make on the state side is that the home is not the only place that ought to receive the dignity and respect, that you don't have to see this necessarily. And if there's any other place we're going to include on a list that is probably short, at least under the court's cases, it ought to be a funeral. That's a tradition that crosses borders, crosses cultures, the respect for the rights of burying the dead, recognizing the dead, memorializing the dead. And it really is a sacred setting. And you can draw a line just around funerals if the court chooses to, with relative ease, frankly. It doesn't open the door. No one in the case is suggesting that you can go down to the courthouse or you can go down to Main Street to go shopping in Massachusetts and not have to see anybody that might be saying something you don't want to hear. But this is a funeral, so and it is targeted. Again, they could get their message out. They can go stand on any street corner in Lawrence, and just all the motorists that go by, they can share their message. Nobody's arguing they can't do that. But what we're arguing is they can't go right to the funeral, basically. Now, they don't go inside. They don't try to disrupt the service per se, but they want to be there so that the people attending the funeral will see what they have to say. And then they're attacking those people. So they're not even going to, say, KU, where they have issues with KU as an institution, which they do, and hoping all the students and faculty see their message. They're going to an event that is really for a deceased person, a private event, a private family, and that's what they're targeting. And that kind of very focused targeting in a setting that is sacred and unique, arguably, is what the states are arguing should be prevented here.
And I know you want to ask another question, but all I will say is you can protect against a lot of what you're talking about with a federal statute that prohibits protests, all protests within a certain distance of funerals. Telling someone that they can sue based upon an offensive message that causes emotional distress, that cannot be limited only to the funeral setting. The way that the courts work, that kind of precedent can be used anytime a protester does something that somebody thinks inflicts emotional distress around medical clinics, animal rights protesters, anti-abortion protesters, environmental protesters. So although I think the Phelps are a very unique group, I don't think that a precedent that comes from this case, a decision that comes from this case, cannot be limited only to funerals in the same way that a law that regulates where and when they protest can be limited.
Yeah, let me just say to that, I agree that
This is great.
I
Keep
agree
going.
that the laws are easier to sort of generalize. So a statute that says this applies only to funerals obviously is limited to funerals. And that's what these laws that most states and the federal government have passed now say. But on the other hand, the tort is not without any limits either. I mean, I am a torts teacher, and I see many of my students in the audience. The tort of intentional infliction of emotional distress has pretty high standards. As Professor Wells said, it really is sort of a disfavored tort in the law. Courts grudgingly acknowledge it. But to prove it, you have to show intentional or reckless conduct that is extreme and outrageous and that causes severe distress in the person. So I think the tort itself could be read to impose limits here. So in other words, if you're protesting the Phelpses are doing their thing outside a courthouse or even outside a school, I suspect the courts would not be willing to say that's extreme and outrageous in that setting. But in the funeral, the argument is it is extreme and outrageous, and that is the limitation in the tort. Is there some subjectivity to that judgment? Sure. Can you be absolutely sure other courts won't invoke the tort in other settings? No, you probably can't. But I suspect that the courts could be given the message by the Supreme Court that any expansion significantly here will run into First Amendment concerns outside of this context. The state courts will heed that kind of advice from the Supreme Court. But I think the tort itself, I also want to emphasize, as my students know, I emphasize with them, the final element of the tort is it has to cause severe distress. And again, that's what Snyder proved here. Now, whether people think he actually did or not is beside the point. The jury found he did, and the Phelpses didn't appeal. So it's not just someone who's offended by the Phelpses. What they do has to cause severe distress, and the courts are pretty stingy in finding that standard is satisfied by plaintiffs under that tort.
I actually do agree that I think most people who tried to bring those kinds of lawsuits would lose because I think they wouldn't meet the elements. The problem is the way that the tort's set up. As you pointed out, it's intentional behavior or reckless behavior and it has to be deemed outrageous. And it's that outrageousness standard that's so difficult. The court's actually already found that in a different case involving intentional infliction of emotional distress. In a case involving a public figure, Jerry Falwell, in a very salacious cartoon about his first sexual experience in Hustler, where he also sued for intentional infliction of emotional distress. The problem with outrage is the way that our emotions work, we get angered or outraged because we perceive someone to have engaged in a demeaning offense to our person. I mean, psychologists know this. This is the appraisal theory of emotions. Therefore, we are going to respond to offensive speech if we personally believe it to be offensive, and not everybody responds to the speech the same way, with outrage and anger, because it conflicts with our values and beliefs. So the more you are outraged by someone who has said something that conflicts with your personal belief system or your personal value system, the more likely you are to be the person who decides you want to sue. The more outraged you are, and it has to be outrageous speech that basically triggers this, the more likely you are to believe that the person who engaged in it intended to hurt you. Right? I mean, this is all just a psychological sort of reinforcing phenomenon. And I do think where you will lose is because you may not have the emotional distress, but that's not going to keep you from wanting to bring that lawsuit. Right? And it's the threat of that lawsuit, the very fact that it could be brought, that the court worries about with these kinds of tort lawsuits, because the fear that you might be a subject to it and that you might lose it will cause people to change their behavior and to not talk about contentious or public debate. And as we were talking about earlier at dinner, if I were any one of those television personalities right now on television who held up people to ridicule every day, ranging from Jon Stewart and Stephen Colbert to Glenn Beck, Bill O'Reilly, or Rush Limbaugh, I would be very worried about the outcome of this case, because those people routinely, across the political spectrum, hold people up to public ridicule. They do it sometimes for humor, sometimes they do it because they are really outraged at what people do. But the tort elements are outrage, intent, and emotional distress, not outrage at funerals, right? It's any kind of outrage, and that's a very subjective response that anybody can have once that demeaning offense to your person response kicks in.
I'd like to, since both of you are constitutional scholars, I'd like to get your thoughts on what is going to happen with this case. Will the court just address the broader question of tort liability and the appeal, or will the court potentially expand the scope of its decision to get into some of the regulations that a number of the states have affecting these kinds of protests?
Well, with the courts, you never know. It certainly could decide this case just focused on the tort liability, and even within the tort liability, there are a couple issues where it could make the opinion more narrow or broader, depending on what it has 5 votes to do. From the state's perspective, we'd love to have the court say, well, whatever they say about the torts, even if they say you can't impose the liability, the statutes are reasonable time, place, and manner regulations that by and large will probably withstand constitutional challenge. But there's no reason they have to say that. Now that said, it doesn't mean even if the court won't address broader issues, individuals may. We've seen that before. For example, in a great case, it would be the Pledge of Allegiance case, where the challenge was to the under God phrase. And the court didn't actually decide whether that was a problem from an establishment clause point of view, injecting religion into this public observance, because they decided the father of the daughter who was objecting to her saying it didn't have standing to actually bring the suit because he didn't have custody of her. The mother did. But that didn't stop several justices from saying, but here's what we think about under God in the Pledge of Allegiance. So, they have considerable discretion whether they address some of these issues. I will say the statutes are certainly not directly implicated in this case. That is not what this case is about. So I would be shocked if the court said, oh, those statutes are all great. But maybe we'll get at least some hints or some suggestions that is a legitimate thing for the state to be, or even 1 or 2 justices who say, well, maybe the majority strikes down tort liability in this case, but we want to emphasize we think the statutes are still probably valid. That would be helpful from the state's perspective.
I think the court will undoubtedly decide at least one of these tort issues. Obviously, that's going to stick to that. I would be pretty surprised if they went too far afield on the statutory issues. Although if they do, I think what they do is send the signal that because there are statutes out there, many of which are constitutional, and there's debate about several of them, but a lot of them would be fine. They might just need a little tweaking. Because those statutes are there, this kind of tort liability is not something potentially if they decided to rule against Snyder. That's why we're ruling against him. I think that might be something. There is an issue, the invasion of privacy issue that we haven't talked on as much, involves the targeting argument that Steve is focusing on, involves something called the captive audience doctrine. And that, if the court does ever hear one of these statutory cases, a challenge to the statutes, that will be front and center in that challenge. And so to some extent, if they decide the invasion of privacy issue and discuss the captive audience doctrine, they might get at something that's relevant to the statutory cases, but I don't know that they'll talk about them directly.
Both of you are on different sides of this issue. I mean, how would each of you judge a successful, from your point of view, a successful decision by the court? What would that be? What would that look like for both of you?
Well, it might not be that different, frankly. From the state's perspective, the ideal would be to at least have the possibility of application of particularly the intentional infliction tort upheld, even if they find there's a problem in this case or there still has to be another trial. There's a lot of argument about the particulars of the jury instructions and what went on in this case. But even if we lost that issue, indications that the statutes are good will go a long ways, I think, towards satisfying the states. Now, we're in as a friend of the court. I'm not representing the Snyder family. So my guess is for the Snyder family, nothing less than victory on the tort claims is victory. But I think for some of the amici on their side, as long as there are ways to at least, if you can't get rid of them, at least keep the Phelpses in appropriate places at appropriate times, that would be a significant victory.
Am I back? Yeah. I would say that I'm not sure I want the court to say anything about the funeral protest statutes, but I don't want them to outright say that there's anything wrong. I mean, I think I would say that for another day. So in that sense, I do think that this case isn't about those, and I wouldn't want them to go too far afield. My sense on what the win would be, if you call it that, and I'm also a friend of the court, our brief is we are not representing either of the parties, is that the intentional infliction and the invasion of privacy claims, when they're applied to speech, especially offensive messages, it's not that you can't sue based upon intentional infliction and invasion of privacy, it's that the court has to use different, better, more objective standards. So I'm not sure that even I am totally in line with what the Phelps see as a clean win. What I'm trying to do is get the court to create better law that's in line with their jurisprudence, or more clear law that's in line with their jurisprudence. So I would say that I do think Mr. Snyder needs to lose this case, but that my hope is that the court will announce standards that make it clear under which the conditions are that you can sue for invasion of privacy and intentional inflictions, and that those conditions do not involve the ability to sue based simply upon offensive messages.
Okay. I have one last question, and then we'll open it up to your Q&A. So we'll get our two students with cordless microphones out. If you have a question, raise your hand. I'll call on you. They'll bring the mic by, and you can ask your question. You can either direct it to either Professor Wells or Professor McAllister, or you can just direct it at the two of them together. So my last question tonight, I think, is what are the ramifications of this decision? I mean, how far can this go?
Well, I suppose that depends on which way it comes out, right? I think certainly the argument that's made on the Phelps' side of the case is if they lose, this is the end of free speech as we know it. I don't buy that. I don't accept that. And in fact, as I've indicated, I'd probably be happy with that outcome. There is an element whenever you get in these First Amendment cases of sort of what I call many would call the camel's nose argument, that as soon as you let any intrusions or limitations on speech take place, it's the end of the world because nobody's going to be able to talk about anything. And that seems to me unrealistic, completely unrealistic. So again, you know, if the outcome is the Phelpses are held liable, it's not the end of the world. It may be the end of their world, but it's not the end of the world for America or for public discourse or freedom of speech in this country. Again, what standards the court crafts will make a lot of difference in terms of how it then plays out in future potential cases. If the Phelpses win, it's not the end of the world. Again, we may have state statutes that we can defend that will at least limit when and where they can do what they do. There is the old option of sticks and stones, and you know, words will never hurt me. You just ignore the Phelpses. I mean, that in some ways is the most effective response. It's apparently hard for people to do. But you know, I don't think they would still be protesting funerals if they hadn't gotten all the attention they have. If no one paid attention, they'd have quit this long ago and they'd be trying something else. So either way, I don't think it's the end of the world for freedom of speech or for the states.
The way that this case pans out, how everything sort of boils down together in technical legal arguments, it really does have the potential to undermine a lot of different areas of free speech law because that liability is based purely on offensive messages. And I think that that is an important point. Now, if the court were to rule that you can impose liability for intentional infliction of emotional distress and invasion of privacy in certain instances, and here are the other objective factors you have to show, and then it remanded back to the district court to see if in fact those factors existed in this case, I would not see that as a loss. Right? I would see that as the court trying to create a speech protective standard while recognizing that there are times when speakers have gone beyond the bounds of trying to communicate and have devolved into sort of coercive non-communicative speech. But I don't think on the facts of this case that that's going to happen. I think if the Phelps win and Mr. Snyder loses, that I think he is in one of those very rock and a hard place type of situations. He's had a profound emotional and traumatic experience, and unfortunately he would not be the first tort plaintiff to find out that there isn't always a remedy for the wrongs that are done to you. And sometimes the court's reasons for that aren't always obvious, but in this case there is this overarching free speech law.
Okay. I'm going to open it up to your questions and answers. If you have a question, please raise your hand. If, by the way, we encourage students to ask questions, and we actually will give priority to students. So we'll get Andrew first, and then Stephanie, are you with somebody who has a question back there? Okay, excellent.
Would you please comment, both of you, on whether you expect any time in the near future that we may be able to see televised the proceedings of the Supreme Court?
I sure hope so. I think that as newer justices come onto the court, they are more amenable to that. But it's going to take a little prodding still. You have a little bit more experience than I do with that.
Well, I don't think it'll be immediate, but I do think you're starting to have justices appointed to the court who actually understand the internet, who've grown up with computers and are just more technologically savvy. I don't think it will come because Senator Specter introduces a bill. I mean, there's going to be resistance on their part just sort of as a matter of dignity. But I think eventually they'll get there, although, you know, one would have thought they'd do things like releasing audio tapes of the arguments immediately, or even letting those stream over the internet as the arguments are going on. Those could have been done easily already without any intrusion, and they haven't done it. So there is a resistance, and I've heard a lot of explanations for why the resistance. One of them that's most convincing without really justifying it is that because they are so collegial in this sense, the 9 of them, that unless all 9 agree to do something, they're not going to do it. So if there are any holdouts who don't want a camera in the courtroom, that holdout probably will veto it happening. Justice Souter, who said over his dead body, is gone, so that veto is no longer present, but there may be others who more or less share his sentiment. And I think until all 9 are really on board, they won't do it.
the streaming would be great. I mean, at least the audio streaming, because then you'd at least get some sense of what it's really like to hear an argument and the banter. It's not the same reading a transcript. I mean, you sort of get Justice Scalia says something, audience laughs. You know, you don't get, I mean, if you haven't heard Justice Scalia before, you have no sense of what exactly it was that he just did to make, you know, the entire audience laugh at whoever it is standing in front of him.
Okay, Stephanie?
Hello, yes, my question is for Stephen McAllister. You said that it's unrealistic that a decision in favor of Snyder would result in like the end of the world of free speech. But I'd like to know like where you think the line is on where the chilling effect is an important issue, like somewhere less than the end of the world for free speech, but where it's still important.
Well, I think couple answers to that. One, if you look at the briefs, I can't say what everyone argues, and I won't try to articulate all the views, but certainly the state's perspective, you know, we must have said the word funeral 50 times in the brief. I mean, we're trying to draw a line around funerals as a unique setting, because we realize if you start talking about any protest that might take place any place, the court will never accept that. But, you know, the Americans, we come at this, and I suspect, I mean, we all grow up in this country for the most part. If you were born and raised here, it's just sort of part of ingrained in us that people say all these things, they do all these things, and there's really no regulation of it. That's a premise that doesn't fly all around the world. And many of our Western allies, for example, I mean, Germany or France or Canada, our neighbors to the north, it's a crime, for example, to say certain things such as that the Holocaust never happened. You know, if you just say, I don't believe it ever happened, it's a lie. It's a crime, and you can actually be prosecuted for it. Do those countries have no free speech? I don't think so. I mean, they're pretty open societies, lots of public discourse. But this is the American tradition, and I'm not necessarily saying I always disagree with it. In this case, I guess I do. But, you know, the American tradition seems to be anything goes. And we just sort of throw up our hands and say, whatever. You know, it hurts people, that's too bad. It's speech. You know, people have got to be able to say it. And what I'm questioning and what I think this case raises is the question whether that is necessarily the best end result. And it's certainly not compelled by the First Amendment. If you look at the language of the First Amendment, it just talks about Congress not making any law that abridges the freedom of speech. What that means is then in the hands of the Supreme Court for the past 220 years. It's not written down whether you can protest at funerals or not. The court has to decide, looking at all sorts of history and principles and cases. And I guess what I'm raising the question is the American view on this? First of all, I can say with confidence, it's not the only view among civilized nations around the world. Is it the best view? Maybe it is. But I think that's the kind of question this case raises. Maybe it's not.
Andrew, do you have a question?
Yeah, just want to touch on that point there, and this is for whoever wants to attack it. If the court does go ahead and legislate and agree that there needs to be some regulation over funerals, is there going to be some wiggle room or some discussion as to what a funeral or cemetery is, for instance? Because I was actually out on 9/11/06 covering a story in Shanksville, Pennsylvania for the 5-year anniversary of 9/11, and you know the Phelps family was there protesting, and while technically that's not a cemetery or a funeral, I think a lot of people would agree it's pretty close, and many people view it as that.
Want me to take this one?
Sure.
Okay. I think there are two ways to approach that question. The sort of straightforward technical answer to your question is when the states draw up their legislation about what is a funeral or a cemetery, they in fact usually do define what is a funeral or a cemetery. And this is specifically, these laws are specifically designed to deal with that. If they don't define it, almost always, if that law is challenged, the court will try to take the plain meaning of funeral or a dictionary meaning or something along those lines, and they're not going to extend it. I think the second part of your question proves my point, though, which I'm going to say, which is you can't really carve out things as sacred and say that's the only thing we're going to do, right? Funerals are, people deserve dignity, they deserve respect, they deserve privacy, they deserve not to be disrupted. But what about I'm like radioactive tonight. Obviously, it's from teaching at the University of Missouri when you actually have Kansas roots. So that's my plug for my big Jayhawks. There's so many things that we can carve out as sacred. Funerals are obvious, and I think funeral statutes exist, like many statutes do around hospitals and schools, in order to try to prevent noisy and disruptive speech, and that those are fine. But to say that we can carve things out as sacred and stop speech altogether, you have 9/11 ceremonies, you have, Ground Zero, right? That this whole not mosque or whatever it is, not at Ground Zero, but at Ground Zero, that whole issue is really about how sacred that area is. There's a point at which that argument is also never ending. How far do you take it, right? So the kinds of regulation that you have around areas and the reasons for which you have it are really important, and the funeral protest statutes are neutral in that they prohibit all protesters within a certain distance, but they still allow them to protest. What they're trying to do is prevent noisy disruption, interference, harassment, those types of things. They're not saying we're regulating you because of your message. The Phelps motivated those statutes, but they don't only apply to the Phelps, or we forget that sometimes. In fact, there's a really well-known case out of Michigan that has nothing to do with the Phelps, and has to do with an anti-war protester that came about because of one of these funeral protest statutes. So it's not just the Phelps that get sort of caught up in all of this.
I have a question. Stephanie, do you have somebody?
Hello. Locally, the Phelps protests the Dole Center, the Lead Center, and KU Law School's graduation. Will this decision affect the Phelps protesting any of those events?
I wish, but no, I don't. I don't think so. We've gotten pretty used to them at the law school hooding ceremony. Certainly our position is we're not talking about that kind of setting. I understand Professor Wells' point. I suppose you can make the argument that standing outside the graduation ceremony, that's sacred and should be protected as well. We're not making that argument. We are drawing the line around the funerals. So I wouldn't expect even a victory in this case to stop them in those other venues.
Okay.
Mr. McAllister, with regard to your focus on funerals, it's my understanding that one of the arguments that they make is that they're making distinction between public and private, is that the only reason they went back there the way they go other places around the country is because the funeral notice is put in the newspaper. That seemed like a real simple argument, but I wonder if the Supreme Court will address something of that kind, of that nature.
Whether the court will address it, I don't know. They do make that argument in their brief. The Phelpses say, well, this isn't even a private funeral because they put a notice in the paper with the address and the time, and therefore it's basically open to anyone. And I suppose in a sense that's public, but it's not public in the way, for example, that the grounds in front of a school or in front of a courthouse or lots of other places. The KU campus would be public. And certainly the family's intention is to mourn with their friends and so forth, and there may be people who come to show their sympathy. But in my view, that doesn't turn it into a public anything goes sort of, and there's a whole lot of First Amendment jurisprudence about the nature of the forum in which the speaker is speaking. And it would not turn what is generally viewed as a private ceremony into a traditional public forum, for example, like the town square or the street corner sort of setting. But yes, the Phelpses make that argument. Whether the court will say anything about it, I don't know. The Phelpses make a lot of arguments in their brief, and a lot of them, frankly, are based on their view of the world and their view of the facts and their own way of trying to lawyerly justify what they do. And I don't know that the court will get down into a lot of those sort of nitty-gritty, perhaps lawyerly, clever in some ways arguments that they try to make.
I would just add and say that Steve and I are on other opposite sides of the invasion of privacy argument. I actually happen to think there wasn't one here, but I don't think it's going to be because anyone would consider that ceremony anything other than private, right? Even when you go out in public, you're able to create relative zones of privacy. And although they put a public notice in, they're doing that to let friends and family know, and they certainly would have the right to exclude unwanted trespassers or visitors, and I think they would consider the Phelps to be that. So the ceremony itself, I think, is easily off limits, both from tort law and from free speech law, because you have the right to associate with people that you want to associate with and to exclude others. So I think the Phelps would be on very shaky ground with that. The question is, can they stand outside a certain distance away, right, and try to reach people as they're coming in? So the ceremony itself, I think that argument would be a non-winner.
Hi, you mentioned this, that one of the motives might be bankrupting the Phelps, and I was just wondering, normally with free speech cases like the ACLU or groups like that would step in, and what effect the stigma of the Phelps family has on the free speech issues, and what groups are doing to defend free speech, even though it's clearly an unpopular family and unpopular actions.
I think there were 7 amicus briefs filed on behalf of the Phelps, roughly the same number filed on behalf of Mr. Snyder. And the briefs on behalf of the Phelps were filed by a wide range of people. These are friend of the court briefs. One that I rounded up a group of people, the scholars of First Amendment law, right? So people who really felt as though there was real danger to the First Amendment law here. The ACLU did in fact file a brief. There were media organizations that filed briefs. The Rutherford Institute, I think, which is a think tank, filed a brief. Eugene Volokh, who is one of my colleagues out at UCLA, who actually, he and I are on completely opposite ends of the political spectrum, so it should show you that these are not partisan sightings. Also filed a brief on behalf of the Phelps. And I think there was one other organization who I'm forgetting. Oh, Thomas Jefferson Center for Individual Rights. So there were lots of organizations here. Groups of private people as well as civil rights and media organizations that filed claims on behalf of the Phelps.
Yeah, although I do think that I'm not sure the Phelpses work well. You know, they don't necessarily play well with others. And I think they may have had offers of more help with their case in some ways, which they don't accept or reject, because they're a family of lawyers, and so at some level they want to do this themselves. It's also interesting that there are groups amicus groups who filed briefs in the case saying we don't support either side, and there are an unusual number of those in this case. I mean, there may be 3 or 4, but that's an unusual number. Usually the amicus come in, they say we're on this side, we're on that side, but there's 3 or 4 who said, well, look, we're not really supporting either party. And if you look at the briefs, a lot of what's going on is they're saying, don't in any way associate us with those people, but we think there are speech issues that are important here. And so there is a sense where I think some of the amici are very uncomfortable about who they're supporting on the Phelps side of the case. And so there's significant efforts in this case. You don't typically see to distance oneself from the actual party that in some ways you're really arguing in support of.
Yeah, Jay Sekulow's brief was absolutely like that. There was one brief that clearly he had an interest in. It was absolutely aligned with the Phelps, and he refused to actually say that that's what the case was. But his brief clearly showed that.
Right here, Andrew.
Should the burning of the Koran be considered as sacred freedom of speech?
I've gotten that question like 10 times in the last. Free speech professors get that a lot these days. Do you mean should the Quran be something that should be considered off limits? Yes. Well, the flag isn't. And the court has said that, right, that burning a flag is a political statement. And unless you can show that it's done under conditions that are that are intended to and likely to incite imminent violence, or that are directed at another person in such a way that it's going to cause, it's used as an insult in such a way as to cause them to fight back, which would fall under the fighting words doctrine, then you can't punish burning the flag, because it's almost always a political statement, unless you're just punishing it as arson or something like that. I think burning the Quran does, I mean, most of the commentary I've seen, and this is my sentiment as well, is that burning the Quran falls into that same category, right? That as a general rule, you're doing it as a political statement, but that if it's done under the conditions that fall within incitement of unlawful violence or fighting words, it certainly could be punished. I do think that it probably hits a lot closer to home than burning the flag. I know many people are offended by the flag, but at least everyone understands that it's usually a statement against the government. When you burn the Quran, you are burning something that is the very core of another person's religious faith. And that could really cause lots of problems, right? I mean, it's more likely to fall under the fighting words doctrine. It's probably more likely to incite unlawful activity. And I think it also may be more likely to incite emotion or cause emotional distress. But at least technically, I think it falls under the same sorts of protections that you see with flag burning. So no, I wouldn't consider it sacred in the First Amendment sense, although it clearly is in the religious sense.
Well, and I would say it might depend too on the targeting and the context in which it occurs. I mean, if someone burns a flag in a public square, they usually are deemed to be protesting the government, disagreeing probably with government policies. Same way burning a Quran. If you're expressing disagreement with Islam in general or something, that the court is going to see as protected. Now, you go to a Muslim family's house and you go in their front yard and you pile up a bunch of Qurans and you taunt them and you hold signs and you burn them, that may be a different case. I mean, the court actually had a case from Virginia several years ago where it was the burning of a cross, and it's a very interesting case because the court really wrestled with that sort of intimidation, at least potentially, given the historical significance of a burning cross and the targeted audience in some instances being often African Americans. The court said, this could be a crime if certain circumstances are true. If you're just out in a public square doing it, probably not. But when you start targeting people and using that as a means of intimidation effectively, it may lose free speech protection. And that's part of our argument, is that that's really what the Phelpses are doing, is targeting private individuals and signs and things that are not just, thank God for dead soldiers, but also God hates you and you're going to hell. And then the epic on the website is much more about the Snyder family in particular.
I actually agree with your example about the Qurans, that example by burning Qurans on the lawn actually becomes intimidation or a threat. And a threat is another category of what the court calls low-value speech, like fighting words or intentional incitement of unlawful activity. That speech is not intended in any way to communicate anything other than fear. It doesn't contribute to public discourse. And so that targeting is different from targeted protests. It's targeting non-communicative ideas, right? And that's what I just happen to think the difference is between your argument and the Quran burning argument, an example that you give, which I think is a very good one, which is that unfortunately when you target someone with signs, unless there is some reason to think that there's a threat or something else going on there, there's really just nothing but offense, although there are unfortunate consequences as a result of that offense.
Do we have a question in the back?
You've used the term sacred many times here today, and some of the times it sounds like a religious meaning. A lot of the time it sounds like emotional. Is there any clear interpretation of the term sacred in the court's decisions?
No, I don't think it's a term they've necessarily even invoked. It's a way of thinking about this case, and I guess I view it it may have religious connotations. Certainly was not using it in that fashion tonight. I just meant sort of, is anything, another way to say it is there any limit to freedom of speech? Is anything out of bounds for speakers, any setting, any situation? And that's certainly the way I meant it, but it doesn't have a basis in the court's own decisions.
No, I think that's right. I mean, I think when both of us were using it here, it's this sense that you're an attempt to carve out something as beyond the pale, right? As regulable because attacking it would be seen as so bad or so unreasonable that everybody can agree that it is special, right? So it's not a religious meaning, it's a more secularized meaning.
Okay, I think I'm going to take one more question. We have a question right here, Andrew. Actually, I'll take two more, Stephanie, if you want to go ahead and find the last question tonight.
You've made a distinction between the signs and this website. Are there cases that have made a distinction in terms of free speech? I take it that you have to actually log on to the website to see that speech or whatever it is, whereas the other is clearly more public, I guess more public. Have the cases made a distinction in that regard?
Well, we're still waiting on the internet law aspect of the First Amendment because it's pretty new, right? There has been a little bit, primarily in the area of a sexually explicit speech, where the court has made distinctions with the ability, government's greater ability to regulate speech that's thrust at you and that's unwanted versus speech that you have to go seek out. And they tend to put the internet in that latter category. The government has a harder time justifying broad regulations of speech when you're the person who has to go look for it, as opposed to having it thrust at you over some medium that you have no control over. So there's been a little bit there, and yes, they have made that distinction. I'm not sure if it'll matter or not in this case, honestly. The fact that he had to go out to look for it suggests that it's not an invasion of privacy to me, right? Because it wasn't intrusive, right? And I think that's a big aspect, but I don't know if it'll matter in any other way for free speech law.
Yeah, I would say it may not matter. It matters more in the intrusion upon seclusion or the invasion of privacy, because the father had to go find that, I suppose. In terms of the intentional infliction tort, I don't know that it does make any difference, because there you could argue it's still extreme and outrageous to put that on the website, knowing that if and when the family sees it, it will cause severe emotional distress. So it probably doesn't matter in that tort.
And that does seem to be the way it's been played out, that they've tried to rely on that more for the intentional infliction claim.
And I think in part, they actually originally tried to rely on the internet posting for their defamation claim in large part, because that was talking about the Snyder family more particularly, but the court threw out the defamation claim and didn't let it go to the jury. So, in that sense, it's sort of a piece of this puzzle, but it's kind of awkwardly fits together with the actual funeral activities.
Okay, we're going to take one last question. Stephanie, do you have somebody back there?
Could either of you offer a perspective on how you think this is likely to come out, not based on the merits of the case itself, but on the current ideological divide of the court? And if so, how do you think the so-called conservative and liberal wings of the court will come out on this?
I actually think it's a mistake to think of free speech issues in terms of conservative and liberal. I really do. You get justices crossing political bounds or partisan bounds all the time like that in deciding cases. And it's the one area where you can tend to see some really strange bedfellows, unlike other political issues. There's a lot of things going on in this case. The invasion of privacy issue is one that, because there are some precedents up at the Supreme Court level involving this thing called the captive audience doctrine, 3 of the justices really want the most recent one of those precedents to be overturned, right? Really badly, because they view it as they view those precedents as having an anti-abortion viewpoint sort of ideology. So 3 of them, I think, may have granted cert simply because that's way they can get to the invasion of privacy issue and reverse a case called Hill versus Colorado. Unfortunately, this case has some pretty bad facts that tests their mettle on that, right? Those justices happen to be pretty conservative, but they could easily align with the liberal justices who believe that, protecting offensive speech is really, really important. So I'm not sure I could predict partisan lines on this one.
Yeah, I think this is one of those areas, perhaps maybe the toughest area to predict based on those kinds of notions of conservative or liberal. I mean, as Professor Wells says, there's sometimes very strange bedfellows in First Amendment cases. Sometimes they're all bedfellows in First Amendment cases, or virtually all, and they come out unanimously or close to it, and often and usually in favor of free speech. I mean, the flag burning case of now 20 years ago is a great example where you had Justice Brennan writing for a majority, one of the most liberal members ever to sit on the court. You can't make it a crime to burn the flag as a form of protest, but joined by Justice Scalia, who no one accuses of being liberal. And in dissent, you had Chief Justice Rehnquist, who was very conservative in many respects, but joined by John Paul Stevens, who over time became the most liberal sitting member on the court until he retired earlier this year. So these freedom of speech cases are much harder to predict in terms of what you might consider the justice's ideology. And it's certainly a mistake to think the issue is, well, will they agree with the message or not? And if they like the message, they're going to vote for the speaker, and if they don't, they're going to vote for the person or the government trying to limit the speech. That's just not the way these free speech cases tend to play out.
Okay, well, Chris, Steve, thanks for a tremendous program tonight. We really appreciate it.